Mr. Paul Donovan was the principal of Loyola High School from 2005 until 2014. He it was who led Loyola's successful struggle through the court system, beginning in 2008, if memory serves, as regards the challenge posed by the ethics and religious culture curriculum. He is a longtime educator in subjects including religion and philosophy, a popular speaker on topics related to faith and education, and very active in the nonprofit sector here in Montreal. He now serves, of course, as Loyola's president, so welcome, President Donovan. Victor Muniz-Fraticelli is Associate Professor of Law and Political Science at McGill. He is the author of The Structure of Pluralism, an account of the claims of authority made by churches, universities, and other similar associations, and of several articles and chapters about law and religion. He is currently researching the ways in which religious organizations conform to state law while staying true to their internal organizing principles. Dr. Janet Epp-Buckingham is director of the Laurentian Leadership Center in Ottawa, an extension program at Trinity Western University, an institution no stranger to controversy or to the courts, where she is also a professor of political studies and history. Her background is in law, and her research specialization is religious freedom. Her book, Fighting Over God, published by MPUP in 2014, is a history of religious freedom in Canada. Mr. Mark Phillips is Montreal Regional Leader of Borden Ladner Gervais Public Law Group. He represents clients before the courts in proceedings of all kinds, including commercial litigation, judicial review, declaratory judgment, and injunction proceedings, as well as constitutional challenges under the Canadian Charter of Rights and Freedoms and the Quebec Charter of Human Rights and Freedoms. He was lead counsel to Loyola in its court battles, and he is also a man, I can tell you, of philosophical interests, as well as a classical pianist, and we're happy to you as well, Mark. Happy for your presence and grateful to each of you. The Loyola case, as everyone knows, tested the liberty of a Jesuit school to maintain its religious identity while offering a state-mandated course in ethics and religion, to which is attached an obligatory posture of neutrality. In affirming that liberty, the Supreme Court majority and concurring minority offered different takes on the nature and extent of this freedom as it applied here, setting out a number of principles likely to have a bearing on subsequent legal interpretations of religious freedom in a corporate context. Panelists will offer their own account of the significance of Loyola with respect both to the questions it answers and those it leaves unanswered. They will also, I suspect, begin to carry the discussion beyond Loyola into territory not only legal, but yes, also philosophical. They're certainly free to do so, as long as they don't go over 12 minutes.
Thank you, Douglas. Well, it's very much an honor to be invited to participate in this symposium. What I intend to discuss is the issue of state religious neutrality, and I'm going to discuss 4 points. First of all, the theoretical underpinnings of it and the jurisprudential consecration of it by the Supreme Court of Canada. Number 2, the logical corollary of it. Number 3, the problems with that logical corollary. And 4, the issue of its effect on collective religious rights. My remarks will be mostly in English, partly in French, because surtout qu'en plus d'être avocat en exercice, dans mes tentatives de jouer au philosophe avec vous, je vais me référer à certains textes, et les principaux textes sont en langue française, donc voilà. So, indeed, with respect to the issue of religious state neutrality, the seminal doctoral piece was written by Professor José Welling of University of Montreal, published in the McGill Law Journal in 1998, which I'm particularly proud of as a former editor-in-chief of that publication. So in analyzing the Big M decision, he said this about religious freedom. Cette définition donne à la liberté de religion deux composantes. En premier lieu, on constate une liberté positive et négative d'exercice de la religion, ou libre exercice. Le contenu positif correspond à la liberté d'avoir des croyances religieuses, de les professer ouvertement et de les manifester par leur mise en pratique, par le culte et par leur enseignement et leur propagation. Le contenu négatif correspond au droit de ne pas être forcé, directement ou indirectement, d'embrasser une conception religieuse ou d'agir contrairement à ses croyances ou à sa conscience. En second lieu, la liberté de religion impose une obligation de neutralité à l'État en matière religieuse qui l'empêche de privilégier ou de défavoriser une religion par rapport aux autres. Et plus loin, il ajoute, pour ce qui est de l'exigence de neutralité de l'État, sa nécessité provient de ce qu'une intervention étatique volontaire en faveur d'une religion crée une pression incompatible avec la liberté de religion de ceux dont la religion n'est pas favorisée. On comprend donc que l'obligation de neutralité découle d'une certaine manière du droit au libre exercice, puisque le fait pour l'État d'endosser une religion particulière a pour effet de limiter le contenu négatif de la liberté d'exercice de ceux qui n'en sont pas les fidèles. So essentially then, neutrality on this concept flows from the idea that if the state is supporting a majority religious view, for example, then that can be perceived as a form of oppression by others. And of course, Big M drug mart, the case that Professor Welling was commenting on, was a case where the Lord's Day Act, which imposed Sunday religious observance, if you will, on Canadian society generally, in prohibiting commercial practices, was viewed as such a form of oppression by the religious majority on the minority. And in subsequent cases, the Zilberberg case in 1988, where the Lord's Prayer was found to be inappropriate in Ontario public schools, the so-called Elgin County case in 1990, where the Ontario Court of Appeal criticized curriculum that was too Christian in its basis. We see basically the process was one of removing the historical situation of privilege of the Christian religion in its Catholic and Protestant ramifications. And that principle received jurisprudential consecration in the dissenting reasons of Mr. Justice Louis-Lebel, who is with us here today, and I must say I'm very honored to be able to be with him here today, and he'll be discussing these same issues later this afternoon with you. In the case of the town of La Fontaine in 2004. And although dissenting in that case, his reasons were in no way criticized by the majority on this one point, where this principle of neutrality was clearly established. It was referred to in Loyola. Most recently, it was referred to in the case of the Mouvement Laïque Québécois versus the city of Saguenay as being a fundamental principle. So therefore, the state must remain neutral. It can no longer promote a religious position, and it must not assist any particular religion. The other aspect of neutrality that I think is worthy of mention is that, of course, the civil courts do not get involved in theological debates. And there was the Amsterdam case where there was a question of what were the requirements of Judaism with respect to the Feast of Tabernacles, and the Supreme Court very clearly said that they weren't going to decide issues between rabbis on what the requirements of Judaism were. So that, in very much of a nutshell, is the theoretical foundation of the principle of state neutrality in religion. Now, this represents quite a shift in our thinking. Donc, il faut comprendre qu'au Canada, au Québec, jusqu'en 1997, l'État avait l'obligation constitutionnelle de dispenser un enseignement catholique et protestant dans les écoles publiques financées par l'État. Donc, c'était un peu la vision classique, et comme juriste, je ne peux pas résister à la tentation de citer l'empereur Justinien Ier, qui au VIe siècle a codifié le droit romain, et qui a dit, dans son digeste, dans la 6e novelle, il y a deux très grands dons que Dieu, dans son amour pour l'homme, a accordés d'en haut, le sacerdoce et la dignité impériale. Le premier sert les choses divines, alors que la seconde dirige et administre les affaires humaines. Et l'auteur de continuer en parlant du rôle traditionnel de l'Église. De ce fait, la première fonction de l'Église est de donner à l'homme des critères de pensée et une discipline de conduite qui lui permettront de dépasser son état de pécheur et lui montreront le chemin des bonnes actions. L'Église est alors considérée avant tout comme une institution établie dans le monde, en Italie, au service du monde, qui en utilise les moyens appropriés à l'humanité pécheresse, et en particulier les concepts du droit, de l'autorité et du pouvoir administratif. Donc ça, c'est la fonction classique qui a subsisté au Québec jusqu'en 1997. Je me réfère maintenant à Marcel Gauchet, qui, dans son livre « La religion dans la démocratie », fait état, selon une perspective française, bien entendu, mais quand même qui s'applique au Québec depuis 18 ans, pour nous aider à prendre la mesure de ce changement qui vient avec la neutralité de l'État. Donc il dit ceci: « Nul ne peut plus croire, même quand il voudrait y croire, au moins en tant que chrétien, que l'ordre qui nous lie vient de Dieu et nous unit à lui. L'idée que nous pouvions nous former de notre pouvoir de définition de cet ordre, de ses modalités d'exercice, s'en trouve essentiellement transformée. C'est ce qui change la démocratie et la place des religions dans la démocratie. » So there's been a very much a fundamental change then since constitutional reform in 1997, when the Quebec state certainly lost the right and the obligation to provide Catholic and Protestant religious education in schools, which one must admit was very much a significant part of our society. So religion takes on a very different role, but it doesn't have that same structuring type of role that it formerly did. So this brings me to my second point, which is that the necessary corollary of state neutrality is that the state, in principle, is now withdrawing from any metaphysical position per se that it's adopting with respect to final ends of man or of human beings. And Marcel Gauchet goes on to say then, la politique est désormais dans l'impossibilité d'offrir par ses propres moyens des systèmes généraux de sens ou doctrines globales des faits. Ce qu'elle est impuissante à fournir n'en demeure pas moins nécessaire. Aussi va-t-elle tendre à aller le chercher à l'extérieur d'elle-même. La collectivité a besoin de se représenter les buts et les raisons entre lesquelles elle a le choix. Et l'autorité a besoin de se légitimer par la référence aux valeurs susceptibles de donner sens à son action. Même s'il lui est interdit à l'État de prétendre en incarner substantiellement aucune. C'est la gymnastique compliquée à laquelle sont condamnés les détenteurs du pouvoir dans les démocraties d'aujourd'hui. Il leur faut aller chercher l'alliance des autorités morales ou spirituelles, en tout genre, au sein de la société civile, les élever à leur côté, les introniser comme leurs interlocutrices d'élection. Cela non seulement en gardant une stricte neutralité à leur égard, mais en marquant leurs différences. And Charles Taylor makes a similar comment when he says in one of his essays that the point of state neutrality is precisely to avoid favoring or disfavoring not just religious positions, but any basic position, religious or non-religious. We can't favor Christianity over Islam, nor can we favor religion over non-belief in religion, or vice versa. End of quote. Taylor later says, a few pages further on, the problem is that a really diverse democracy can't revert to a civil religion or anti-religion, however comforting this may be, without betraying its own principles. So in theory then, as Marcel Gauchet says, and as Charles Taylor says, the corollary of state neutrality is that the state then is not adopting any particular metaphysical worldview. Rather, it's supposed to be looking to other sources, including religious sources, and for that. Now, the difficulty with that is, of course, it's very difficult for the state to take such a position and to not have any fundamental metaphysical worldview. And one case that I think is worth mentioning is the 2011 1 minute British Columbia reference with respect to polygamy, where the court ultimately upheld the prohibition of polygamy in the criminal code in Canada, but that was severely challenged on the basis that it was fundamentally a Christian position, and there was a party, an amicus curiae, who took that position. The court ultimately rejected it, but on the basis that there was evidence that in fact the prohibition of polygamy could be found in pagan Roman society and could be justified on other non-religious grounds, which suggests that if it had been found to be a Christian value, then it would have had to be rejected, just the way that the Lord's Day Act was. So in point of fact, there isn't true equality in the state neutrality approach, at least not in that particular decision. Rather, the majority religion, or at least the historically majority religion, is relegated to an inferior position. So it's not all that easy in practice then to carry out this theory of neutrality.
So I have chosen to deal very specifically with analyzing some of the things that come out of the Loyola High School decision itself. And I'm going to deal with 4 aspects of the decision and how this either clarified or was a significant progression in the law on religious freedom. The first is administrative law, which sounds really boring, and perhaps it is, but it won't be for long. Yes, exactly. You only have to deal with it for 2 minutes. Secondly, 2 aspects of religious freedom that were significantly clarified: communal aspects of religion and the extent of religious freedom. And then lastly, the application of international human rights standards. So first, looking at the administrative law issues, and most of what I have up on the PowerPoint are actual quotations from the decision. Administrative law becomes very important because cases can come before the courts really in religious freedom cases in 2 different ways. One is an actual charter challenge where you take something to the court, usually legislation or regulations. And the second is if there has been a decision by what's called an administrative decision maker. So in Loyola, it was the Minister of Education who made the decision, and so then there was a judicial review application. There's been a lot of confusion over how these cases get dealt with because they don't go under the traditional charter jurisprudence, and so it's always a question of what test is being applied here. And I think the court seems to be bringing the 2 different procedures a little closer together. And so you see this indication here that the administrative decision maker must proportionately balance charter protections to ensure they are limited no more than is necessary given the applicable statutory objectives. And the issue here is whether the decision was reasonable, and there has to be a proportionate balance between whatever statutory mandate there is. Here there was determination by the minister as to whether this new course, the the new curriculum was equivalent to what was prescribed. It was going to be taught at Loyola from a Catholic perspective, and that's what the minister felt was not equivalent because it had to be taught in this neutral kind of way. So the court is trying to set out very clearly what the standard is. And this is important for anybody else who's bringing the next case along to know what is the test, what are the rules, what do these administrative decision makers have to do. So then we get into these issues of religious freedom. And one of the significant issues is, since the Charter, the courts have made it very clear that Canada, the Canadian state is a secular state. It cannot, as Mark was talking about, it cannot prefer one religion over another. But it then has to have neutrality between religion and non-religion. It can't now prefer secular approach over a religious approach. This becomes very difficult and complicated, and we saw this with the Saguenay case with municipal prayer before, the Lord's Prayer before a municipal meeting. Well, as soon as you say there can't be prayer, you are preferring the secular approach. But as soon as you approve prayer, then you're preferring religion. So that was one of those no-win situations where there is not really a neutral approach that you can apply, because as soon as you remove the prayer, you're preferring non-religion over religion. But I think this statement is kind of the best that the court can say about this, that there has to be neutrality between different groups as much as is possible. And I like particularly the last statement: a secular state respects religious differences, it does not seek to extinguish them. So here we start getting into the institutional aspects of religious freedom. Again, this is hugely important, and this is actually the last significant quotation from the majority judgment on this, on the issues of religious freedom. The courts have generally or initially considered religious freedom to be an individual right in the Charter. And we've gradually, there have always been these statements about, we recognize the communal aspects of religion, we recognize that religion is often practiced in community with others, we know that there are churches and mosques, but wherever they could, they sought to avoid actually dealing with institutional religious freedom, because there's been this sort of sense of, well, then you get into conflicts between individual religious believers and their institutional bodies, and how are we going to deal with this? We don't like the idea of group rights because they could be oppressive against individuals. But finally, in this case, we're seeing a fairly strong affirmation of the value and importance of religious communities to religion itself. So here this final statement: ultimately, measures which undermine the character of lawful religious institutions and disrupt the vitality of religious communities represent a profound interference with religious freedom. Now that sort of brings some comfort to the wide variety of religious institutions and organizations that exist across Canada. Well, then the minority decision in Loyola was even stronger than that, indicating that religious corporations can have institutional religious freedom. And so I've put the minority judgments in yellow so that they're distinguished from the majority judgment. And here we have the communal character of religion means that protecting the religious freedom of individuals requires protecting the religious freedom of religious organizations, including educational bodies. Now, I'll get to this more about this right at the end, about international jurisprudence supports this conclusion, but also indicating that Canadian jurisprudence supports this conclusion. So what the courts are saying is, hey, we've been building towards this, we've been moving in this direction, but this is the first time the courts are really saying, yes, religious institutions and religious communities have their own religious freedom protection. The individual and collective aspects of religious freedom are indissolubly intertwined. This is such an important concept for many religious communities across Canada. I mean, there was a previous decision dealing with Hutterian Brethren, and they are the most strong religious communities holding property and farming communally in colonies. They eat together, like it really is like a church farm. So unfortunately, in the Hutterian Brethren case, the courts went against the religious freedom that the Hutterites were asking for, which was an exemption from a mandatory photo driver's license. But there was a strong recognition in that case that there was a community that needed to be considered, but the colony itself did not have a group right. Now, moving on to the extent of religious freedom, the outer limits to what is protected by religious freedom has been an issue that people are constantly concerned about. Where, can anything be brought in under the umbrella of religious freedom? But here the courts are making it clear that it isn't just religious beliefs and practices that are being protected, but actually also the propagation of religion, which can include, evangelism, witnessing, education. Those aspects are also an important part of religious freedom. Sometimes it's just freedom of worship that people talk about when they talk about freedom of religion, but actually this affirms that the concept is much broader than that. Again, this is from the minority judgment, but I don't think that I think the decision was the minority part was really on a different point. Also quoted Big M Drug Mart, which has already been mentioned. Funny name for a case that's the seminal case on religious freedom, but there you go. We lawyers who live in the world of religious freedom are very familiar with the Big M Drug Mart case. But even in the Big M Drug Mart case, there was an indication that we need to have a generous interpretation of religious freedom, not legalistic, not narrow, but looking at what religion really needs in order to protect it. So finally, the international human rights standards. This is very important to recognize that Canada looks to international human rights standards as being the minimum standard that Canada is going to adhere to. The minority judgment looked extensively at international human rights treaties, at decisions from the European Court of Human Rights. And I think it's helpful to recognize that we're in a global situation for religious freedom, and there is a great deal out there on the global scale, particularly in Europe, that is helpful in other areas where there's a pluralistic countries. How are they dealing with religious freedom in positive ways? How are they dealing with institutional religious freedom that we can draw on when we are looking at how these issues are going to be dealt with in Canada?
Now, I think that the first thing to note, and something that I noted in an article that I co-wrote with a former student of mine that should appear at the Osgood Hall Law Journal by the end of the year, is that the Supreme Court of Canada has never actually ruled on the question that it asked in the Loyola case, whether religious organizations can invoke Section 2A rights to freedom of conscience and religion directly. The Loyola case, in fact, is no exception. And I think that the contrast in the answer that the majority opinion and the concurrent opinion give to this question is both philosophically illuminating and also illuminating when it comes to doctrine and the development of doctrine. I think, in fact, I started reading the opinion, which was, in fact, on its face, a unanimous opinion, the Loyola opinion, thinking that I would be extremely sympathetic, especially in light of the Alberta versus Ontarian Brethren case, with the majority opinion. And by the end of it, I realized that I was much more sympathetic with the concurrence. And that got me thinking of why. Now, I knew some of the reasons why right away. I am a legal and political pluralist. I believe in associational autonomy, understood in a very robust way, going back to the writers on associational autonomy from the early 20th century, like Donovan and others. But also because the particular controversies that are coming before the court now seem to be of a kind that are better addressed by something closer to a jurisdictional understanding of religious authority, which the concurrent opinion was much clearer on. So I think this is ultimately a question of what some philosophers of action and social philosophers have called a social ontology. Social ontology is the discipline that studies those kinds of entities that make up our social world. So you could have a completely individualistic social ontology and say the only entities that really matter are individuals, and associations are merely contractual artifacts or simply manifestations of custom. They are not real things. On the other side, you could have what some of the pluralists, especially the German influenced pluralists of the 19th and 20th century had, which was a deeply organicistic version of a social ontology, where things like churches, and not only churches, but universities, guilds, cities perhaps, are effectively persons in a fully developed way. And I think that there's been enough criticism of that position to cause us to re-examine it. I have, in fact, re-examined it. I think that there's ways of regrounding it on contemporary notions of philosophy of action that have to do with the way in which human beings make decisions when they are embedded in some kinds of associations. But from the legal perspective, we don't have to make a deep philosophical decision, although we have to acknowledge that there is a deep philosophical question at stake. At issue on questions of social ontology is ultimately a question of authority. The question of whether religious organizations get to be effectively the authors in both the contemporary sense of writing or creating their character, their lives, and also I think importantly in a historical sense of the kind of power that they claim to exercise, namely autoritas, the moral suasion or the power of moral suasion that is contrasted with coercive force as understood by medieval political theorists. This is the power that the church claimed and the power that still many of these associations claim for themselves. I think that ultimately this question of authority is manifested in a particular misfit between the authorship of religious organizations, of their own bodies, of their own organizational principles. Religious organizations are not in fact constituted by the fiat of the state. You have to be a radical Erastian to think this. I think that even Hobbes in his more sober moments thought that religious associations were in fact constituted by their own internal principles of association, and that is why they had to be submitted. But in a liberal society, we understand them to be constituted by their own principles. They don't understand themselves to be creatures of the state in any way. In fact, many of them, if not most of them, predate certainly the state of Canada and most of the states of the modern community of nations. And they are also what Robert Cover called juris-generative organizations. They create law, they shape law, they understand themselves legally, they understood themselves legally before states understood themselves legally. And they present this kind of organization as very often as a complete, or at least aspirationally, complete legal and administrative system. Nonetheless, they have to exist in the world, and even John Neville Figgis, as one of the more radical religious pluralists of the early 20th century, recognized that the church may require that organizations give proof of their structure, their officials. The state is still the arbiter of contract and the protector of property. So that these religious organizations, despite the fact that they have their own internal principles of organization, use secular law to make this organization's structure effective. They may take different forms because the religious principles of the organizations take different forms. They are sometimes Episcopal, sometimes Congregational, sometimes Presbyterian. And especially in a liberal and democratic society, there will often be a misfit between the secular and the religious principles of the organization, so that the secular principles will not perfectly mimic the religious. Again, as I said, at issue is a question of authority. Now, I take my bearings on authority from Joseph Ross, who's one of the major theorists of authority, and to put it quite simply, his account of authority is that we're justified in submitting ourselves to an authority if we are more likely to comply with those reasons that apply to us in any case by submission than if we were to try to discern these reasons directly. Ross, however, believes that these reasons exist quite independently, and that perhaps different people can analyze them and different people can say your interests perhaps lie in this direction as opposed to that. And this is what makes him, while someone who defends group rights in some form, who defends collective rights in some form, an interest theorist of rights. He believes that rights exist in order to protect interests, ultimately the interests of the individual. In the case of groups, this could be the interest in the goods that a religious community provides, the interests even that congregants have in the preservation of the religious community itself, not only in the goods it provides, but in thinking that the existence and persistence of the religious community is a good in itself. There is another account, however, of rights, which I think corresponds to a different conception of social ontology, and that is the will or choice theory of rights. And the will or choice theory, instead of identifying interests as the reason why rights are justified and exist, claims that the will of the agent, the capacity of choice, the capacity of rational self-direction, is what is protected by right structures. Now, the only thing that is necessary in order to have a right in this case is to have the capacity of choice, the capacity of self-directed action. I would argue that many religious organizations, because of their internal structures, because of the decisional procedures that are completely internalized by their members, and render the decisions of the organization something that is more than merely the sum of individual interests, and there's plenty of social theory to give evidence of this, are proper choice makers, proper will possessing agents in the will theory of authority. So let's look at the Loyola decision. And let's look at it in context. First, we can look at one of the precedents for this, the far precedents of this, a Hutterite case, but not Alberta versus Hutterian Brethren, rather Lakeside Colony versus Hoffer, where Chief Justice McLaughlin issued a sole dissent to an opinion regarding the application of law by a Hutterite organization. Part of the issue in that case was whether the Hutterite Church, as such, and the Hutterite colonies, which were several, were one and the same, where the colonies were organized under secular law in a particular corporate conception. And the church was, as I recall, a rather unincorporated entity that was nonetheless granted some religious recognition by virtue of the religious rights of their members. However, the church did not see it this way. The church saw that the colonies were merely a manifestation of the mission of the church. These two things were the same. There was a misfit between the church's own conception of its organization, including the organization of its colonies, and the discipline that it could exercise in those colonies, and the way that the colonies were organized in secular law. Under the interest theory, which I believe reflected in the Loyola decision, it is the place of the judge to decide what the interests of the members are. The judge may defer, if the judge so wishes or considers it appropriate, to the judgment of the religious authority, but I think that even the Anselm case would pose some impediment to that, as a religious authority could be understood as a kind of expert that should not be definitive. However, under the will theory, the church itself is the rights bearer, and you simply defer to the authority that the church itself has manifested. And I'll give a couple of examples in the minute that I have left of the places in which I think this is relevant. I think it was relevant to go really far back. I think it was relevant in the so-called Gibord case regarding the authority of the Roman Catholic Bishop of Montreal to determine who was excommunicated and who was not excommunicated for purposes of burial in a Catholic cemetery. The Anglican Privy Council judge who decided that case probably decided it more correctly in terms of canon law than the partisan archbishop. Nonetheless, the archbishop was not final because he was infallible, although infallibility here doesn't quite apply. He was infallible because he was final to cite the words of the U.S. Supreme Court judge. It was the right decision in that case was the decision issued by the right authority. Canadian law has been moving in this direction in a case like UCC versus Anderson, for instance, where the doctrine of the United Church of Canada had changed, and one of its parishes argued that because of that change, it should be able to take control of the trusts because it held doctrinal continuity with the original doctrine of the church. This regarded the ordination of gay and lesbian priests. But the Canadian courts decided that it was continuity in structure, in hierarchy that mattered, more than continuity in doctrine. The Anglican property cases that have recently come up regarding the reaffiliation or attempted reaffiliation of conservative Anglican parishes with conservative dioceses in Africa, especially Nigeria and Uganda, have also been decided in favor of the national church, again claiming that it is continuity in official structure and not in doctrine that ought to matter. Okay, and one last case that was not taken by the Supreme Court of Canada to show that this is not just a Christian problem. Sandhu versus Siri Gurdwara case of Alberta, where the Gurdwara was organized under the Religious Corporations Act of Alberta, which has a sublatory law, the Business Corporations Act. And a judge determined that the religious council that drew up the membership lists of the Gurdwara was effectively going to be overruled, and a judge, citing the remedy of oppression found in corporate law, would rewrite the membership rules of a religious organization on the basis that that was the secular structure. That, I think, is where jurisprudence is headed, and that is why I think the concurrent opinion is, in fact, more promising than the majority.
Thank you.
Good afternoon. I just want to start by saying that the perspective that I take here is going to be a little bit different from my colleagues, and that they are all immersed in law, which is not my area of expertise. But I do want to look a little bit at some of the implications of the decision that came for Loyola, but also in context of what it was we were trying to accomplish in the first place. I do want to start by making at least one comment which I didn't intend on making regarding corporate religious rights. And I think that for us, in embarking on this case, one of the things that became important was the idea of Loyola High School as Loyola High School having a right to its faith base, to its perspective, as different from even the collection of the individuals. So I really appreciated Victor's comments there. But it's the idea that, these kinds of things are practical in that we have discussions at board meetings, for example, as to whether or not a particular decision that we want to make is fitting, is in keeping with the identity of the school itself. As if the school has an identity, and that's different, even if every parent in the school decided that they were suddenly atheists and were no longer Catholics, that would not change the nature of the institution itself. And I agree that I think that kind of support is stronger in the concurring judgment than it is in the majority judgment, which tends to conflate the idea of institutional rights with the collection of the individuals that are part of it. So again, I'm not so sure that was actually completely dealt with, which was one of our hopes, is that would be dealt with more specifically in this case. The topics that I did want to mention, first of all, it's just a little bit of an overview as to whether or not, in terms of looking at the decision, whether or not the minority or the majority remedies were the preferred remedy. And I have to admit that I'm not 100% sure as to which one I believe is the proper remedy or sort of covers the most bases. On the one hand, the minority decision that Justice McLaughlin's writing for the minority was the one that we immediately sort of gravitated toward and said, well, that's sort of capturing it. And I certainly think that in the case of Loyola, it fit what we wanted and what we hoped for. But I think that there were some issues that the court had to deal with that are reflected in the majority, and that's in particular dealing with institutions or potential future cases or whatever the jurisprudence sort of sets up for what happens in the future. And in our case, I don't think there was a judge on the bench that felt that Loyola was trying to do something that was really going to be potentially damaging or contrary to what the government program was trying to do. And so I think that's very much reflected in the minority judgment. But the question still remains, and in fact we were asked that, Mark was asked that directly. Well, it's great, if it's Loyola and we're going to do all these things, but what happens if some other group comes and asks something else and we're not so sure about where they stand? And I think that the majority judgment is trying to reflect that reality a little bit more. I think, although the minority judgment does have a series of criteria which I think are excellent for looking at how it could be. So I'm just to say that my initial response to the judgment was one of a great deal. I was very attracted to the minority judgment, but I do think there are some things in the that I said attracted to the minority remedy, but I do think there are some things in the majority that are important to consider. Okay, the main points that I wanted to address has to do with a complete framing of the case. So this is a little different than looking at the specific judgments that are there. But for me, there was something very interesting in the way the court decided to frame the whole issue. So for me, I think a little bit of history is going to help with this in looking at what we tried to do when we first went into to looking at bringing this case to court. And so for Loyola, part of the problem was this. So we just to frame it. The ministry was saying that we needed to teach something that was supposed to promote tolerance and respect of others in pursuit of the common good. And then in order to do that, we had to abandon our faith perspective. Loyola felt that, first of all, we didn't need to abandon our faith perspective, and second of all, that maintaining our faith perspective, in fact, would accomplish the goals better than what the ministry proposed program was. And so initially, and this was a lot more evident in the Superior Court case, we basically decided to emphasize the differences between the two approaches, in some cases strongly criticizing the approach that was mandated by the government, and looking more specifically at what Loyola does and saying that this in fact will achieve those ends better. As the case sort of moved up and ended up in Supreme Court, the emphasis shifted a little bit, and it was a strategic decision on our part, and I think also one that was sort of reflecting what was going on in terms of the judgments that were coming from Superior Court, then Court of Appeal, and what we expected from Supreme Court. And the judgment, the strategy shifted a little bit to be focusing more on the idea that the requirements of ERC were requiring us to abandon our faith, not just in looking at other religions and ethical positions, but specifically in terms of looking at our own. And I think that is strongly reflected in the majority remedy, that they really gravitated toward that particular argument. So the problem is this, and I just want to read the framing that Abella puts on the decision. So the question here is whether or not the decision of the minister to not grant the equivalency, Loyola is saying that what we're doing is equivalent, to not grant the equivalency is framed this way. It says, the reasonableness of the minister's decision in this case, therefore, depends on whether or not it reflected a proportional balance, which we heard from Buckingham, is that Buckingham? Proportional balance between the objectives of promoting tolerance and respect for difference and the religious freedom of the members of the Loyola community. Now, I just emphasized the members of the Loyola community to my earlier point. But what for me really strikes me here is the idea of it setting up immediately something as being oppositional. So what we've got, and in this, it's quite different when we're looking at this case versus any other case of sort of religious freedom. The content of this case matters. So, and the example would be, if this case was about, a government regulation that prohibited the wearing of religious symbols, and then you say, okay, well, there's a conflict here between I want to wear my religious symbols, my faith tells me to wear it, and a regulation that the government has that says you can't do that. But what's significant here, and what makes this even different, is the content itself of what it is the school is being asked to do. And this is to promote tolerance and respect of others, and That's what the course is about, that's what the decision of the ministry was about, and essentially the decision is to say that to take a denominational approach cannot accomplish these goals. So why I find this interesting is that the framing of the case is saying that there's an immediate sort of distinction or separation or an oppositional sort of position between promoting tolerance and the common good and a religious or denominational perspective. And that we need to look to balance as to whether or not if we allow the religious perspective, it won't hurt too much the ideal that we have of promoting tolerance and the good. So for me, the framing of it is already slightly problematic in terms of what it was that we were trying to accomplish. Because essentially, what Loyola is arguing is a good, solid Catholic education promotes tolerance and the pursuit of the common good and the respect of others. It's not something to be, well, you know, we don't like it because it really doesn't quite do it the way we want, but we'll allow it because it's religion. It's actually saying that the religious perspective enhances what it is the government was setting out to do. So for us, the question was not so much, is there an opposition between the two? It was to say, for us, the conflict was in them saying that there was a problem. I'm not sure if I'm clear with that, but the idea is that when the ministry says that the school cannot promote those values from a denominational perspective, that's what we object to. It's not we're not asking for an accommodation to say, we really don't want to teach those things and we don't want to teach them because we're religious. We're saying we already do that. And the objection that we have is to the implication of the government that we don't. And that shows itself a little more strongly in the majority, in the majority judgment. So there's a couple of things in the judgment that I just want to read that I think are somewhat problematic. Okay, so the context of this case is state regulation of religious schools. This raises the question of how to balance robust protection of the values underlying religious freedom with the values of the secular state. So it's the idea that somehow or other these two are oppositional values that need to be balanced. And then she states that the ERC program has two key objectives: the recognition of others and the pursuit of the common good. The first objective is based on the principle that all people possess equal value and dignity. The second seeks to foster the shared values of human rights and democracy. By imposing this program on its schools, Quebec seeks to inculcate in all students openness to diversity and respect for others. So that's the way they're framing the objective of what ERC is supposed to do, and somehow or other this is seen as oppositional to what Loyola tries to do. So for us, that is a problem in the framing of it. Now, I don't know that, given the way constitutional issues and things like that are dealt with, whether or not a different framing would have yielded a different result. And that was certainly a discussion that we had in our strategy going into it, whether or not we wanted to go more fully at saying, the problem that you have, and it was sort of raised in terms of state neutrality, is that in order to make a determination as to whether or not a Loyola program or what we were doing could achieve those ends, would require the state to look into the religious doctrine of Catholicism and then make a judgment. And that, of course, is problematic. So what you end up with then is if an Islamic school or a Hindu school or a Jewish school comes and says, well, our religious beliefs promote these as well, and these came before the court, well, the judges would have to determine whether or not Catholic doctrine, Hindu doctrine, Islamic doctrine promote those ideals, and that's problematic for it. So I'm not sure that I have a sort of solution for it, but I do find that the framing of that oppositional nature of state values or liberal democratic values and religious values as being by nature oppositional, and whether or not that sort of creates the idea that we have to either assume from the beginning that either religions are compatible with the liberal democratic values of a society, or that they're not, and then deal with cases that come up with that assumption in mind already. And I believe that the way it's working is that there's an assumption of an incompatibility, which is problematic. I'm out of time. The last issue, I'm just going to mention it very quickly, that I think was really important, and I believe it sort of framed the whole thing. Phillips talked very quickly about the idea of state neutrality, but the issue of neutrality itself, again, because of the content of this particular case, goes right into the core of what this case was about. And it's the failure to distinguish between the idea of neutrality in the perspective of presentation and objectivity. And I just want to read this one section that for me is, and I believe it stayed a problem all the way through, but in Avella's decision, she writes that the risk of allowing a Catholic perspective in teaching of this course runs the risk, and I'll read her paragraph, runs the risk of an approach. The risk of such an approach would be that other religions would necessarily be seen not as differently legitimate belief systems, but as worthy of respect only to the extent that they are aligned with the tenets of Catholicism. First of all, I don't believe that's true even from the perspective of Catholic doctrine, but this contradicts the ERC's program goal of ensuring respect for different religious beliefs. Quick point that the idea of respect for beliefs is not the same as respect for the individuals who hold those beliefs. And I believe that the goal is actually the respect of the individual, not of the beliefs itself. Someone believing in the spaghetti god I may respect that person but don't necessarily have to respect that there is a spaghetti god or that that's a wonderful belief. In a multicultural society, it is not a breach of anyone's freedom of religion to be required to learn or teach about the doctrines and ethics of other world religions in a neutral and respectful way. So she uses the word neutral and respectful here, and I'm going to finish in a second, Doug. In a religious high school where students are learning about the precepts of one particular faith throughout their education, it is arguably even more important that they learn in an objective way about other belief systems and the reasons underlying those beliefs. She uses the terms neutrality and objectivity as synonymous, and they're not. That a neutral position, saying that I take no position, versus, I can believe in black holes and present the scientific view that there are no black holes in an objective way without having to be neutral on it, to be able to take a position. The same thing can be true with religious values and religious beliefs, and I don't think that ever came through in the judgment in making that distinction, which to me is relevant to this case, and I'm way over.
I interestingly gave a talk last night where I was talking about religious freedom in Magna Carta. So going back 800 years, Article 1 of Magna Carta protects the institutional religious freedom of the church in England. Of course, there was only one church at that time, that was the Roman Catholic Church, but there'd been a fun fight over the appointment of the Archbishop of Canterbury, and the church was kind of making it clear, we have the right to determine who our clergy will be. It shall not be to the state to make those kinds of determinations. So these issues between the state and religious institutions go back a very long way. And religious institutions often will form their institutional structures around the state-provided structures, even if they don't fit. And often the religious institutions will happily continue on in whatever method they actually have of processing things, even though their constituting, incorporating documents say that they're operating in a completely different fashion. And this is sort of the ongoing issues for religious institutions to try to maintain who they are and who their identity is with a state structure that really doesn't fit. And the Hutterian Brethren case is a really good example of how that ends up. The courts start looking at it and they say, oh, here's your legal documents, which bear no resemblance to how you actually function. So the issues of how the state deals with religious institutions and how religious institutions view themselves is really a huge one, and one that I think nobody really recognizes until a particular case gets to court. And I don't really know what the answer is to that, but that's kind of another issue to kind of grapple with.
Yeah, and if I could just add to that, so in terms of this issue of the Loyola's rights as a school, and I must say I was astonished when the Attorney General said that Loyola as a corporation does not even enjoy freedom of religion. There was a little bit of basis for that, unfortunately, and I'll just raise 3 points very, very quickly. Now, again, just from a French perspective, I'll just cite again from my friend Marcel Gauchet, the difficulty there's a famous quote from Le Chapelier which says, il n'y a plus d'intérêt particulier que chaque individu et l'intérêt général. So there's the overall social interests of the society as a whole, there's individual interests, but there's nothing in between. And so that's not really an approach that's been commonly taken here, but in the area of religious freedom, the difficulty was with the Amsterdam case where the test became sincere belief as opposed to whatever Judaism as a whole might have as an opinion on a particular issue. Well, then you're really fragmenting it and you are making it more of an individual thing. And I'll just close with one final quote from Marcel Gauchet, where he talks about individualism, which can be positive, but it can also be a negative thing. He says, nous tenons ici l'une des sources de l'individualisme de type nouveau que nous avons vu se répandre dans la dernière période, et la source qui explique l'un de ses aspects les plus déroutants. Nous étions habitués à l'idée de l'individualisme affirmatif émancipatoire. L'individualisme que nous avons sous les yeux apparaît davantage subi que voulu.
I just wanted to make a very brief comment when it comes to, just to, not to backtrack, but to qualify the normativity of some of these arguments. It is true that if religious organizations are allowed to set the terms of their internal organization, and if in cases of doubt, so for instance, in cases where there is a trust set up 200 years ago for the preservation of Anglican practice in St. Mark's Parish, it is the Anglican Church of Canada, as opposed to the members of St. Mark's Parish, who get to decide what is proper Anglican practice, even if doctrine is changed on important matters. Someone is likely to lose out. And in hierarchical organizations, it may be that we are reinforcing clericalism. The choice very often is whether we are going to have in a society where people can enter and exit religious organizations with quite a bit of freedom, whether it serves the cause of religious liberty more to have religious officials have more power over their members, or whether it serves the interest of religious liberty more to have judges who are not part of that organization have power over these members. And I think that is ultimately the question. It is not a question of an ultimate good or an ideal situation, rather one of competing authorities, and which grant of authority serves the interest of religious liberty more properly.
And perhaps one final point I would add too, I think that in the Supreme Court jurisprudence generally that we're seeing now, we have this recognition of the value of association. So we have Section 2D, freedom of association, and of course some very important cases earlier this year with respect to union associations and the labor movement and the right to strike, and certainly those rights have been very much increased as well. And perhaps Justice Lebel can tell us about that this afternoon. He certainly played a very instrumental role in all of these developments. But I think we're in a situation where, despite the fact, as I was saying a moment ago, that a Charter of Rights type approach inevitably tends to make everything a question of individual rights, and therefore to fragment society into individuals on the one hand and state on the other and nothing in between. Yet there is a countervailing tendency, which I think is very, very positive, to affirm associations generally, not just religious ones as in Loyola, but associations of all kinds in our society. And I think that's a very good thing.
I think that the imposition of an objective standard in presentation of varying points of view, varying perspectives, varying religions, is a legitimate, I mean, that's just an academic mandate, is to be objective and when we're presenting something. But objectivity does not imply neutrality. And that's the point that I was trying to get at earlier. So, I mean, one of the other problems with the whole case is actually the term Catholic perspective, because I think that was understood very differently from probably the different judges, probably from the different people that were presenting, certainly from the media. And a Catholic perspective does not mean that everything that is being discussed gets framed again as to, well, the Catholics believe this, and so if, in other words, we're presenting Hinduism and talking about multiple gods and saying, yeah, but we've got to realize that Catholics don't believe that, there's only one, and you shouldn't believe what Hindus are saying. The idea of objectivity is not to pretend that you as an institution, you as an individual, have no perspective. Neutrality tries to create this pretense of no perspective at all, that I have no. So the questions that I ask, the ideas that I'm getting across are neutral. First of all, I challenge whether or not that's even possible, that whether or not it's framing it. But being objective in presenting other points of view, other ethical positions, on whether it's questions of sexuality, whether it's questions of belief, I believe that that's possible for us, and in fact it is part of the methodology that we use. But at the same time, never to pretend that there isn't a perspective that we have as an institution and that we want our students to understand. And those are two very different things. So again, in the way that was dealt with, I think it was a confusing of what being objective means and what neutrality means. So I'm not sure if that completely answers your question, but...
And if I could just pick up on that, I mean, I think just to come full circle with the point I was trying to make in my opening remarks at the very beginning of the panel, I think that one, if I'm saying anything, it's that there's one inherent philosophical weakness in the whole state neutrality concept, is that the state, as much as it might try, finds it very difficult to be neutral, and there will be public policies that are infused with content of one description or another, and which is very rich normatively. So certainly one point we stressed, as Mr. Donovan pointed out, I mean, certainly the program that Loyola was putting forward as being equivalent had the same objectives. The two objectives are recognition of others and pursuit of the common good. Now, what made the case easy is that those two principles are actually borrowed from Catholicism. So it wasn't too tough to sell that. But certainly, I can see with the various tests that have been set out, be it in the majority decision or in the minority decision, which is more sort of a technical approach and it's bullet points and different criteria. But if a school came forward with the same request for an exemption, saying, well, no, we don't believe in pursuit of common good or in recognition of others, well, then obviously the outcome shouldn't be the same. And so, I mean, whether we like it or not, we're in a situation where the state is not all that neutral after all, and it's having to, in a sense, adjudicate claims based on the amount of tension there may be between the state's position and that of whoever's making the claim.
I think also that there's a problem that is fostered by the way that legal education is conducted. In focusing mainly on the test that the judges will apply in situations like this one, I think that if we get to the point where a question like the question of how do you teach sexual morality in a religious context when there is a mandate to teach it ethics in another way, if we get to the point where a judge has to determine the kind of accommodation that is to be found in a religious school for that kind of mandate, there has been a failure in the legislative and administrative consultative process. And perhaps some substantive guidance would be welcome when it comes to that legislative and consultative process. So for instance, when you're going to teach interfaith dialogue, is it better, as the government seems to think, to approach interfaith dialogue from an Archimedean point that says, well, interfaith dialogue means that all the faiths sit together around a table in this rationalist construct of what a dialogue ought to be? Or is it better to actually go out there and ask the people who direct all the religious schools and engage with them directly and say, well, if you can't enter a church, what can you do so that we can still talk? Can we have the meeting in a synagogue? There seems to be this apprehension at making any kind of concession, even at the level of dialogue with religious authority, where a process of consultation would probably preempt many of these challenges. Now, the program that will result from this might actually be a lot more pluralistic and heterogeneous. You might actually have slightly different approaches in different schools and a mandated latitude like effectively what the majority opinion of Loyola says, after they say Loyola has to teach ethics and other religions from an objective and neutral perspective, then there's 10 paragraphs that say, but we have to accord them all this flexibility, which kind of, it's a way out of what I think was a clearly unreasonable demand. So if we incorporate that flexibility from the start in the consultation for the law and for the administrative program that comes out of that law, it requires a different relationship between the churches and the state than what we have now. That comes way before the time when a case comes before the court.
Can I
Briefly, yes.
just as another comment along with that, and I think it comes down to, again, the idea of talking about seeing religion as oppositional. I think there's a question of understanding what religion is, because even in this judgment, it talks about, well, when you're teaching Catholicism, you have to do this, but when you're not teaching Catholicism, well, I would answer that, and this is why, in one way, the majority decision doesn't matter to me at all, because, well, we're always teaching Catholicism. In our English class, we're teaching Catholicism. In our football field, we're teaching Catholicism. Like, religions are not about just a set of doctrine that we learn in some time. It's about a whole way of life. And in a Catholic school, essentially, you're always doing that. And so, what the judgment allows is to say, well, when you're doing that, you're allowed to be what you are, and so that's fine with me, because we always are. But I'm saying that there's a fundamental misunderstanding, I think, there that can separate and say, well, when we're doing religion, we're going to do this, and that's what I mean about taking religion and sort of seeing it as something that's different from really, it's part of what someone is. It's not just a separate little, like their cultural practice on Christmas or something like that, which can be seen as a separate entity. Religion is a holistic thing, so I think that's not clear in the way the judgment comes down.
I wonder whether we might even turn that coin over and ask the state to think about how far it can detach itself from a civil society that is trying to live a life in collectively and individually, in which some of these fundamental freedoms are acknowledged and respected. I stayed up last night. I shouldn't have done this, but I stayed up late reading Saginaw again. And I often, when I do look at it, I can't get past the first sentence. The state is required to act in a manner that is respectful of every person's freedom of conscience and religion. Sorry, the first couple of sentences. This is a fundamental right. Its corollary is that the state must remain neutral in matters involving this freedom. So this morning in the first panel we talked about the question of rights, conflicting rights, over the issue of medical assistance in ending your life. The state has to take an interest in that. The judgments have been made and will be made. Can the state do so without taking any positive stance, any definitive stance, we might even say, about the value of human life, about this right to autonomy? Why should the state affirm a right to autonomy? Where does it get the worldview that posits that right? What presuppositions and what corollaries of that are implicit in the state saying, well, this is one of the things we absolutely want to protect. It's a seamless web, in other words, and I think it's one thing to criticize religion or to misunderstand religion is what you're suggesting, yes, by saying it's really religious components can be confined to some particular ideas and rituals. It's another thing to say that the state can function without any real commitments to one particular worldview or another. And I took that to be a question raised by Mark Phillips in his quotations as well in his own paper. I think we have to think about the credibility of this corollary that the state must remain neutral in matters involving this freedom. If it's going to remain neutral in all matters regarding this freedom, why is it not neutral about the freedom itself? Why does it hold to the freedom? Why is it prepared to support the freedom, to legislate on it, or to demand, in the case of the courts, that there be legislation? So, you know, there are a number of really basic questions in all of this that have perhaps not been asked yet clearly enough. And I hope as we go throughout the day we can think together about the intersection, some of it hidden, but the intersection between these topics that we're looking at, and also, of course, between some of the cases. That said, it is 1 o'clock, and some of you are feeling even hungrier than I am. And so we will stop. I want you to join me in thanking our panelists again, Mark Phillips.